I'm April Green. I'm the directing attorney in the Family Law Unit at the Legal Aid Center of Southern Nevada. This segment concerns custody. If you want to establish custody of a child, you first need to ask yourself whether jurisdiction is rightfully in the state of Nevada. And the short answer is that if the child has lived here for 6 or more months, we are probably the home state of the child and you can start the case here. If you think you have jurisdiction issues or problems, you probably need a legal consultation with an attorney. And be advised that at the Legal Aid Center, we do manage with the Self-Help Center a program called Ask a Lawyer, where you can get a free legal consultation to deal with those kinds of complicated issues such as jurisdiction. Dial 386-1070 and follow the prompts for Ask a Lawyer to sign up for a free consultation with an attorney. Getting back to custody, to start a case, the basic forms that you will need are the summons, the complaint for custody, visitation, and child support, the family law cover sheet, and the joint preliminary injunction, which is an optional form. You can get these forms by buying them, the packages from the Self-Help Center at the Family Court, which is located at 601 North Pecos Road in Las Vegas, or you can get the website address and simply download the forms and complete them, file them with the court, or you can even type them online and print them out fully completed and then file them with the court. Now, the complaint is really the main document where you not only tell the court, the judge, but the other party what you are seeking from the court. The beginning of the custody complaint will ask basic information such as residency, are you a bona fide resident of the state, whether you've lived here 6 weeks or more before you filed the case. A lot of the lines in the form are simply checks. Other information would be the name of your children, the dates of birth of your children. There will also be a line for you to spell out exactly how paternity was established. If you need more information on what to write on that line, I'll refer you to the video in this series called Paternity. So you'll literally handwrite that in, type it in, you'll put all the basic information on the form, and then you'll get to the a little more complicated questions wherein you will have to decide what to ask for in terms of custody, visitation, holiday visitation, health insurance provisions for the child or children, and child support. Right now, I'll talk about your choices for custody. The two main types of custody that you'll have to deal with will be legal custody and physical custody. I'll talk about legal first. There are two main choices that you will have for legal custody. One will be joint legal custody, the other will be sole legal custody. There is a presumption in Nevada towards joint legal custody. Simply put, the legislature decided that it's in the best interest of children for both parents to have legal custody rights. And the two main areas for legal custody are the right to obtain records concerning your child directly from providers without having to get records through the other party. In other words, if you want your child's school records or if you want the pediatrician's records, if you have legal custody rights, you are able to go to those providers and as a parent get copies of documents regarding your child. The other main area for legal custody is the right to participate in major decisions concerning your child, as opposed to day-to-day decisions. An example of a major decision would be For instance, whether your child should go to public school or perhaps to Catholic school or to a religious parochial school. If you have joint legal custody, you have a right to participate in those kinds of decisions. Another example would be elective surgery. If your kid wants a nose job, for instance, the other party shouldn't be able to make a decision on something like that without talking to you about it. So these are your basic parental rights. And if you want those rights and you want the other person to have those rights, then you will check joint legal custody. But if, on the other hand, you feel fully justified that you should be making those major decisions alone and that the other party should not have access to records concerning your child or children, then you want to check the box for sole legal custody. But I must caution you that the court frowns upon a sole legal custody, and you have to have very good reasons to justify the court awarding sole legal custody. But when you're filling out these papers, we often call it your wish list. So you can ask for whatever you want, and if the other person doesn't answer your papers and defaults, you may very well be awarded what you asked for, including a request for sole legal custody. So now I'm moving on to physical custody. Physical custody is probably the one most people think about when they throw out the term custody. Physical custody means where the child resides, where physically the child is kept and where the child's home is. There are three types of physical custody. There is joint physical custody, which is, people throw out the term 50-50, but it actually can be more like a 60-40. But the bottom line is that the child will live with both parents. The other option, one of the other options is primary physical custody, which is probably the most common one in terms of what people request. And with primary physical custody, the child or children lives with one parent and visits with the other parent. If you want primary physical custody and you get primary physical custody, then you will be able to ask for statutory child support, whatever the law says you should get. In terms of percentages of the other person's income, you will be able to get that if you have primary physical custody. Generally speaking, you will be able to claim the child or children for taxes, and mainly the child lives with you, you're making the day-to-day decisions, and the child will visit with the other parent. The other option is sole physical custody. So once again, you're completing your custody complaint, you'll make those decisions, and you'll move on to the visitation section of the complaint, and it will basically ask you to spell out what you want to happen with the major holidays that you and your family participate in from year to year. And the common way to handle that, and the form of course gives you, choices to check off the appropriate section, but say, for instance, a major holiday may be Thanksgiving. You got to decide whether you want to just deal with the day of Thanksgiving or the entire Thanksgiving weekend, which could end Wednesday before Thanksgiving at 6 p.m. and then end at 6 p.m. on Sunday after Thanksgiving. You'll have to make that choice, and then you will have to break down the hours for the exchange, who will get that particular holiday on what particular year, what time the child is picked up, what day, and what time will be the drop-off. And the important thing about that is that, generally speaking, it's easier to alternate that from year to year, and we use terms such as odd and even. Mother will have Thanksgiving Day, for example, in even years, and in odd years, dad will get the child on Thanksgiving days, and so on and so forth. If you're not very specific in your complaint and the other person defaults in the case, then you're not going to get a very specific order, because generally speaking, the complaint and the final order must match. So if you want a firm, specific schedule in your order, then you have to take the time to be specific in your complaint. The next area will be health insurance. There will be choices as to what you want the court to order for health insurance, that the plaintiff or the defendant, will be primarily responsible for maintaining medical insurance and or dental insurance for the minor child. The language sounds something like that. So you'll make the choice. If you have traditionally had the job and covered the children and you want to continue with that, then you'll check and say plaintiff or defendant, whatever the case may be, and let the court know how you want that handled. Generally speaking, in Nevada, in terms of custom, if insurance is not provided through employment, or if you cannot obtain it at a reasonable cost, the court usually will not compel either party to provide it, when they cannot afford it. Also, generally speaking, anything that's not covered by insurance, such as co-pays, prescriptions, so on and so forth, will be equally divided between the parties, and that language will pretty much already be written into the complaint. So that's one of the other things that you'll have to make choices about. And finally, you'll have to make specific choices regarding child support. You'll have to disclose the information that you know, for instance, approximately what you believe to be the monthly gross income of the other party. You may have to say what your gross income will be as well. Oh, that reminds me, I didn't talk about joint custody very much. And if you choose to have joint physical custody of your child, where they will be co-parenting and the child will spend nearly an equal amount of time at both homes, when you get to the point of choosing what to do about child support, you will have to disclose the approximate gross monthly income of both the parties. If you know what it is exactly, you'll have to state those figures, because child support is different when there is joint custody between the parties. And we also have a video in this in our series specifically on the subject of child support. So because of that, I won't talk much about child support in this particular segment. So you're going through your complaint, you're checking off what your choices are, and you get to the end. You may or may not have to sign it in front of a notary public. You'll have to look at the forms. If you do know that there are notaries at the Self-Help Center and Family Court. And I also want to say that if you're not starting the case, but someone serves you with a complaint for custody, you will have 20 days to answer from the time that you were served, and the answer can also contain a counterclaim, and in that your counterclaim will look very much like the complaint, and you will then have to state what your choices are, what your wishes are for all of the things I previously discussed, and file your answer in a timely fashion with the court so that the other party is not able to default you. Now, let's assume that you're the plaintiff, you started the case, you filled out the complaint and all the other documents I mentioned, you filed it, you paid your filing fee, or you got your filing fees waived, and now you're waiting the 20 days to see if the other party is going to answer. For this example, let's assume that they did not answer, and now you need to finish up the case. You will need to take the transparenting class, which we also call the COPE class. You can get information on the COPE class at Family Court. The cost is $40. The class is anywhere from 2 to 3 hours, and what they seek to do is to help guide you in communicating with your children during a breakup of the family, whether or not you live with the person, it's important to know how to communicate with your children while the parents are separating or have separated. And that is what the COPE class is all about, teaching you how to communicate and be positive with the children. Another thing that you'll have to do is to find someone, a friend of yours, it could be a relative as well, but someone who will attest to the fact that you are a resident of the state and that you were a resident at least 6 weeks before you filed your complaint for custody. That person can come to your prove-up hearing, and prove-up hearings, by the way, are in this series of videotapes. You can listen to the prove-up tape video to learn what to do about finishing your case. You can bring your resident witness to the prove-up hearing, or they can file an affidavit attesting to the facts regarding your residency in the state of Nevada. Let's say you've taken the COPE class, your resident witness has completed the affidavit. You can finish up your case by either completing the setting slip and going to a prove-up hearing and finishing up there, or some judges will allow you to finish a custody case by a process called summary disposition, where you complete a package of papers and you submit your proposed final order, which you have previously filled out, and you attach that order to your resident witness affidavit, proof that you attended the COPE class, a file copy of your complaint, and another affidavit which is completed by you, and you submit those forms as a package to your judge's department. And if everything is in order, some of the judges will sign the final order, and your case will be almost done. If you use the prove-up hearing process, you will get your order signed at that hearing, and you will submit, in either case, your final order. You will e-file that order through the clerk and get a file stamp copy of it, which you will serve upon the other party. And your final step will be to complete a form called notice of entry, which you will attach the final order to that notice of entry and file the notice of entry with that order with the clerk. And that is a final step in terms of finalizing your case in a way that makes it complete. So I hope this has been helpful, and good luck with your case.